Heather Honey is not a detective, lawyer, or physician, nor does she play one on YouTube. Although, she does have a Bachelor's of Science degree in education. Opinions are her own because she is stingy.
This is a true crime channel. Some videos may have content that is disturbing to some and contain coarse language. Viewer discretion is advised.
I don't know. I've waited so late in life to see how important the justice system is. And now, I follow a lot of people. I've learned a lot through trials. I watch Brandy Churchwell on 13th Year live stream podcast. Y'all need to check her out. I watched the Travis Rudolph case, and I've touched a little bit on that. That one was fantastic and really woke me up about our justice system. So that is part of the reason why I wanted to do this. And check out Defense Diaries. Bob Motta and Ali Motta are fabulous. Bob, if you're watching this, which I doubt because you're a busy man, but if you are, you and I, we are on the same page, buddy, when it comes to the Delphi. And we will talk about that hopefully one day, maybe, if you'll come on my show. We'll see. But anyways, and I'll put their links down in the bottom, like I said in the chat. I need to check them out because we're wanting transparency in the courts. So many high profile, they don't want cameras in the courtroom. Well, I want to see what's going on, not to try to get somebody in trouble, but I want cameras in the courtroom because I want to learn more about our justice system and what works and what doesn't work and what can we do to make it better, because I'm a problem solver. That's just my nature. So that's my thing about the cameras. And so that's why it's so important that I wanted to share about this Murdaugh business with you guys, because trust me, I believe he is guilty of sin. I knew he was the day that it came out about Maggie and Paul. Murdaugh, they did their motion. They're like, Becky Hill, tampered with the jury. And if you missed that, you can go back and watch the other video I did on that. So now the state and Ms. Hill have responded. And this is the state's response to defendant's motion for a new trial and state's motion to strike. In other words, they don't want Murdaugh to have another trial. Murdaugh filed in the Court of Appeals of South Carolina on September 5th, 2023, a motion to suspend appeal and to leave to file motion for new trial on October 17th, 2023. The Court of Appeals granted the request to hold the appeal in abeyance and remanded the matter to this court to permit Murdaugh to file his motion, blah, 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 blah. So in other words, what that meant was they're saying, okay, we're going to put your appeal process on pause and we're going to leave it right here. And then we're going to send this matter back down to the court where you got the verdict of guilty. Murdaugh broadly claims that he is entitled to a new trial based upon allegations that the Clerk of Court of Colleton County, Becky Hill, improperly attempted to influence the jury's decision in support of his claim. Murdaugh offers affidavits from one juror who participated in deliberations, one who was removed for dishonestly concealing her own improper communications about the case, and two, and you see where I've got that underlined in red, two hearsay affidavits from his counsel's paralegal. And I mentioned that last time. I was afraid that was going to be a problem. You should fill it out. There are ways to get help filling out an affidavit if you have problems with reading and writing. But so Murdaugh additionally advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support it. Y'all, when these attorneys fill out these motions and responses, I just like for them just to tell it like it is. But these where they're using these flowery words and stuff, it's like, did Becky herself write this? Because This is just as dramatic as her book. And yeah, I said it. And no, I haven't read the whole thing. I just read those couple of pages that were in the exhibits last time, and that was enough for me. I didn't have none of that mess. Be real, y'all. You know, if you see something on social media that you were like, oh my goodness, you know you're going to screenshot the hell out of that thing and you're going to send it to everybody you know. And I may or may not be guilty of that myself. But whatever the case, you know you're going to screenshot. Y'all, you know she would have screenshotted that. That's just my opinion. I'm not saying that's what happened. I'm not saying she made it up. I don't know what happened. But anyways. All right. So the state responds as follows. Number 1, law and procedure. Colorable claims of after discovered improper external influence on a jury may necessitate a judicially, I can't talk today, conducted inquiry to confirm the validity of the verdict as free from external influence through which defendant must show actual prejudice. Okay. So in other words, what this judicially conducted inquiry, it's a formal investigation. And I'm for that. And then prejudice, in this case, harm or injury from some action. Okay. So the law permits but skeptically receives motions for new trials based on after discovered evidence, and never does the law permit highly motivated convicts to put their own jury on trial. I agree, but this is not this situation is not what they're. This is not the same thing. It's apples and oranges. It's pears and spaghetti. It's just not the same thing. And going back to that, convicts can't put their own jury on trial. Well, I don't think they're putting the jurors on trial or wanting to put the jurors on the trial. The jurors would need to be witnesses, not on trial. They're not going after the jurors. They just need the jurors to tell the truth. And like I said before, Murdaugh, guilty of sin. He did it, no doubt. But here's my thing with the justice system and why I have a problem with if she really did say something to these jurors or give them any ideas. And it didn't matter if it swayed their vote or not. She had no business discussing the case or intimidating them to make certain decisions. By no means. Because I'm telling you, it's got to be fair. They've got what's good for this person has got to be good for that person. It doesn't matter who it is. We've got to keep it the same. It's got to be fair, and we need transparency. And so I got to get off my soapbox or we won't get done. I can't talk about dogs. I discussed in the other video is when they're making these motions and they're writing. It's like, writing a paper. So if you make a statement that you feel is true, then you back it up with a law or case. Or the cases that they used, if you can see where I've circled right there, the year is 1881, y'all. And this one down here is 1800. And that one says to procure unprincipled witnesses to contradict the evidence on the part of the state and thereby defeat the ends of justice. Okay, we're not talking about evidence that was presented in the, it wasn't presented in the trial. This is after the fact. So what has this got to do with how much rice is in China? I mean, I don't understand that. 1800s. I mean, that right there, we've got to update some laws and get some changes done if we're going to have a better justice system. So, okay, so moving on. Nonetheless, criminal defendants have a right to a fair and impartial jury. That is correct. I agree. And private communication or contact with jurors during a criminal trial about the matter pending before then may necessitate an evidentiary hearing, and if the defendant can show actual prejudice, a new trial. I totally agree, because remember,
4 cardinal rules. Thou shalt not engage in any discussion, even amongst yourselves, about this case until you get back there in the jury room to begin your deliberations after the end of the trial.
tell it, Judge.
2, thou shalt not do any research of any kind, electronic, in a book, talking to anybody else about this case or what others believe the law to be. None of that whatsoever. No research whatsoever of any kind at any time, even after your deliberations begin. 3, keep an open mind. You still have not heard one teeny, itsy bitsy little bit of evidence yet. You haven't heard any yet. I'll let you know when you're going to hear the first bit of evidence. And 4, in the event during a break, you'll be stepping out of the courtroom and somewhere outside of the jury room. It is conceivable that you'll run into one of us. You'll see one of us out. By us, I mean myself.
Right,
I mean the lawyers. I mean Mr. Rudolph. I mean our clerk. I mean anybody. We will not talk to you. We will duck you. We are not intending to be rude, as I've said before. We are simply trying to make sure that there does not even begin to be the appearance of an inappropriate communication between any of us and you. So please, you duck us, we'll duck you, and everything will be hunky-dory.
All right, exactly. You duck us, we duck you, everything will be hunky-dory. Now, I understand she's the clerk of court, but if these allegations are true, she stepped out of her bounds. Court has long held that the remedy for allegations of juror partiality is a hearing in which the defendant has the opportunity to prove actual bias. I agree. And here we go. We're in 2020. Thank goodness. I mean, I just went through this and highlighted what I thought was important. There was parts in here where it says jurors are presumed to follow the law as instructed to them, like I showed you that video of Judge Gillian, which I love his 4 cardinal rules. I mean, you just can't help but remember that. And what upsets me is Judge Newman should have handled it at the time, but right now we don't know for sure what all he handled. All I know is we need some transparency. And not every comment made by a member of court staff to a juror is going to pertain to trial. But here's the thing. It goes back to that little analogy I told you before. If you're taking a test, and back when my days we had a pencil, you had to have a number 2 pencil to take a test, and you would have them on your desk and you'd be writing, and then something happened and maybe the pencil flew off. Well, it was out of your reach and you had to ask a student next to you, hey, will you hand me your pencil? Well, if the teacher is looking at you, what does it look like to the teacher that you're doing? It looks like you're cheating. Whether it's, well, there just shouldn't be comments. Like, I think every comment should have been like, addressed as a group. And apparently they were in 2 rooms. So why is that normal? I thought that jurors were in 1 room. But through this trial, they were in 2 separate rooms. And that confused me. But I feel like if they had any personal issues that they needed to talk to her, which was brought up in this response, then, let's get back to elementary education and raise your hand and say, Miss Becky or Miss Hill or whatever they called her, I need to have a discussion with you. And then that lets her know, okay, it's going to be something that's important and private. And then set a time and meet with the judge, her, possibly the court reporter, and then maybe one more person, and have in chambers a little meeting. And end of story. Then you don't have to worry about. And if this is true about going to the bathroom and having little talks, Y'all, I'm going to be pissed off. Again, some of this, I feel like it's not pertained to this situation. This is a weird situation. I watch Peter on The Lawyer, and I believe the other night, and yes, I'll put his link in there. He's good too if you just want a quick little summary of what's going on. I think he mentioned, like, this is strange. This doesn't normally happen, and especially with the Court of Clerk. But anyways, so right here it says, generally, juror testimony is not allowed regarding the deliberation of the jury or internal influences. So what are we supposed to do? The jurors were the witnesses. So they can't testify? I mean, here's what I think they should do. Now, who am I? I'm nobody. Oh, yes, I am. I'm somebody. But whatever the case, they should question the witnesses. Now, I don't know these legal terms, so you'll have to excuse me, but I'm just going to try to word it the best I can. Let's have a hearing or a meeting or whatever, and question these jurors under oath. These affidavits, I thought they were going to take them seriously, but when we touch on the ones that the state had completed, both sides, I don't trust them now. And see, Judge Newman was part of this. So is he a witness? So is it going to go to somebody else? I mean, how does this work? I'm confused. If you have any answers for me, please put it in the comments. I would love you for that, because I really have no idea. And it's driving me nuts. Like, they could use this case to back up their response. And it was talking about how let's see here, the bailiff, there was allegations of improper communications between a bailiff and a member of the jury. The trial court questioned each juror and the bailiff, which proved there was no reasonable possibility the bailiff's comments influenced the verdict. But how do you know that? How do you know for 100% fact Miss Becky or whoever else didn't influence the jury? We don't know that, because remember, there's always two sides to every story, and then right in the middle is the truth. And usually we don't get the whole truth. So, yeah, I'm upset if you can't tell. Jurors are citizens who have committed a tremendous service. Okay, yes, I agree. They did their civil duty, and I am appreciative that jurors that do, but this is serious. This isn't like playing around, folks. They shouldn't be wasting their time filling this out. They should have been said, okay, these allegations, we don't know if they're true or not, but let's get down to the nitty gritty and let's find out if they're true or not. And this was, now I have to admit, this was a little bit more clear for me. And I don't think I really got to explain it last time, but what happened was this juror was taking an appliance, dropping an appliance off to a tenant. Now, this is the one that had supposedly, I think, has to do with the Facebook post too. But anyways, so juror 785 went and she dropped the refrigerator off to her tenant and his wife or girlfriend or whatever. Of course, they're going to bring up the trial of this small town. That's what you do when you go out and about and you see somebody and you'll be like, hey, what you think about that Murdaugh trial? In other words, she let them know she was on the jury. And then, so they were like, well, what do you think? Well, first of all, why are you doing that? Don't put her in a position. I'm not taking up for her because she shouldn't have said nothing. But don't be putting people in that position. It's none of your business. She is trying to do her duty as a juror, and there you are being nosy. So if you know somebody that's a juror, don't be asking them crap, because it's none of your business. You will find out later in the newspaper or the Walter Burr word of mouth or whatever Facebook small town group you got. So there's that. Okay. Oh, I'm sorry. Usually I'm like, hey, but this has really got me fired up. So anyways, so she told them that she really hasn't made a decision because, basically she hasn't seen all the evidence. So, I mean, that was the right answer, but still, the point is when they say don't talk about this to anyone, you don't talk about it. I mean, you don't talk about it because, again, people think you're doing something wrong. So that's where she messed up. But they did the right thing. They questioned her. They got proof. Even her husband said that, yes, she did have a conversation. So that's why she was dismissed. Had nothing to do with the Facebook post, just like Judge Newman said in court. When the defense attorneys did their press conference and they were like, yes, and our friend Joe McCullough, because y'all know how Pooty is, he's got a grandstand and he's going to be over there. He's somewhere walking around over there and he's going to be representing juror blah, blah, blah. And so the jurors have already started getting legal counsel, and I don't blame them. Eric Bland is helping some, and you guys need to check him. He's awesome as well. Again, I'll put his link down in the description. The state moves to strike as inadmissible hearsay the affidavits of paralegal Holly Miller, and that's what I was reading last time. Their affidavits were typed up, and I thought it was nice because you could read them. But there were a couple that it made no sense as to why those people did not, why it was done over the phone or why she was sitting in front of them. And she, typed up what, because that is hearsay. It's the telephone game. It's the grapevine game. I don't think it was like trying to do something bad. I think they're just trying to hurry to beat the clock. And that's what I think about that. So B, the state moves to strike as inadmissible under rule blah, 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 such materials as regards internal functions and deliberations of the jury. And then it says, as previously noted, jurors may neither testify nor make report except affidavit, which pertain to the matter of statement, blah, 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 blah. Okay, again, how are we gonna fix this? If you can't ask the jurors questions and you can't accept affidavits, then what are you supposed to do to correct this? I have questions and I want to know what they're going to do. Like, I want to know right now, but I mean, I know that's not happened, but it's driving me nuts. I don't like this rule here. I don't like it. Okay. So then C, the state moves to strike all such material as regarding Murdaugh's claims regarding the Facebook post, book deal, and post-trial media interactions as immaterial, impertinent, and scandalous. Okay, I disagree with that. It might be proof that she did, tamper with the jury. There was some weird stuff written in the book on those exhibits that were like, and we looked at each other's eyes and we all knew when we were at Moselle, and then the sun came down, and yeah, I just cracks. Anyways, and yeah, I made a little note right here that Becky probably wrote this part too. The greater part of Murdaugh's motion is dedicated to an outlandish theory. Okay, it's not outlandish because let's talk about some social media. Y'all know that people will do stupid stuff on social media. And a lot of us Gen Xers are like, whoa, thank goodness the internet didn't come on until after we were older. But it's plausible because there was this girl. She was living with a police officer, and they were together for several years. I don't know how many years. I don't know. But anyways, and so his ex-wife came back into the picture. So then he dumped that girl, went back to his ex-wife, And that girl went on Facebook, created a fake police officer from another town and that she was in a relationship with. And then she got some of her family members to be friends with this fake person. And I'm like, are you for real? Don't be so pitiful that you got to make up fake people on Facebook and to make it like you're already dating somebody. Who cares? So my point is it possible that somebody got on there and made up some Facebook post and put it in the Walter Burr word of mouth? Heck yeah. Where's the screenshots? Because people screenshot. We all screenshot. Okay. So, and again, I mean, here we go. They're grabbing the court expressly. Did not rely on the alleged Facebook post in removing juror 785. Therefore, whether Clerk Hill saw the alleged post is mistaken as to the alleged post or even fabricated it is of no consequences to the validity of Murdaugh's conviction. This is not the point. Let's take out Facebook. She allegedly talked with jurors privately. And the jurors were in 2 separate rooms. I still have a problem with that. Now, of course, during deliberations, I'm going to hope they were in the same room. Surely to goodness they were. But 2 separate rooms during the whole trial that was 2 years long, it felt like. So, although Murdaugh's motion for a new trial makes various allegations as part of its attempt to craft a breathtaking conspiracy narrative, oh my gosh, it ultimately boils down to a single constitutional allegation. Clerk Hill told jurors not to believe the defendant, thereby violating his right to an impartial jury. Accordingly, even if the state assumes that ad arguendo that all of the competent elements of the affidavits provided are earnestly given, the relevant analysis is as demonstrated by the questioning in that case that they referred to earlier, where the juror's verdict was guilty. Was the juror's verdict based on evidence presented? Was the juror's verdict influenced the alleged outside communications? Did the juror have any communications about the case outside the deliberations? All the details are irrelevant. There we go. Window dressing. Okay, no, it's not. Because when you answer these questions, was the juror's verdict guilty? Yes. Was the juror's verdict based on the evidence presented? I'm going to say yes, because that was what they were supposed to do. 3, was the juror's verdict influenced the alleged outside communication? Or was it? Okay. If they say no, okay. Did the juror have any communications about the case outside deliberations with the jury? Okay. So we know that one did for sure, and she got booted out, which was correct. But this other thing, even Judge Newman said he did not like that the clerk of court was questioning that juror. Because guess what? It wasn't her job. And y'all, when it's time for voting, and y'all know how it is in these small counties, when it's time to elect judges and all these elected officials that in the judicial system, you better be doing your research on these folks, or you might wind up with a busybody who writes a tell-all book before she's even done with her position and using that platform to earn personal money. She just needs to say, what do you want for lunch? Well, actually, I think that was another person's job. But, do you need something? As a group, as a collective group, she doesn't need to be having one-on-one discussions with people. This is where we got problems. All right. Argument 2. Should the court deem an evidentiary hearing necessary, the state expects the material allegations will be shown to be not credible. Okay. Again, I'm just trying to get through this, so we're not here for 5 hours. In the event the court concludes Murdaugh has made a showing sufficient to necessitate an evidentiary hearing in this matter, the state expects that sworn testimony to the court will proved the allegations to be unfounded and not credible. Since Murdaugh's filing in the Court of Appeals, blah, 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 have successfully interviewed most of the jurors and the final alternate juror, one juror declined to discuss the case or deliberations. And 2 jurors are represented by attorney Joe McAuliffe, remember Poots Buddy? All right. Who at the time of this writing has yet to consent to an unconditional interview with his clients. Well, no, they're not going to do that. They're not going to talk to them. And then Clerk Hill denies commenting to the jury regarding Murdaugh's defense or testimony. Well, of course she's going to deny it. But look in that book, and I can't believe she wrote that. Okay, so Exhibit A, affidavit of Mary Rebecca Hill. Upon information and belief, SLED's investigation into the allegations of jury tampering produced the following answers for the jurors who deliberated. So, here's the juror numbers, and they've got 193, 254. It's not relevant to us. Okay, this juror said no. Oh, here, did you hear remarks on evidence by Clerk Hill? No, maybe generally pay attention. Okay, she don't need to be saying that. Why is she telling him what to do? Who gives the instructions? I think it's the judge, not her. This other juror, watch Murdaugh's body language. Inappropriate. Graphic material warning. That is not her place. If you are on a murder trial, I'm going to use my common sense, and I'm going to believe that there is going to be graphic material shown to me as a juror. So I don't need the clerk of court to remind me or warn me or whatever. I'm fired up. Okay. And then the next juror, they said no, they didn't hear any remarks. Okay. The next column said one chats by Clerk Hill with other jurors. So the first one said no, second one said no. Third one said, yeah, that's the third one that said about the graphic material warning. Yes, saw chat, and it was about financial and child support. Why are we talking? No. First of all, if you have a problem financially and this is going to be a burden on you, you are supposed to let them know. And they say who can stay and who can't and all that. That's when you're supposed to tell them. So why are we talking about it now? Oh my gosh. Okay. And then third column, other concerns. And then that first juror that had said, she mentioned about generally pay attention. Okay. If anything, people were overly cautious. I don't know what that means by that comment. Okay. So then we've got the next column, and of course it's on 2 pages. So this juror said no, she was generally pay attention, look at body language, and be observant. What are you y'all, if we have another trial, well, I personally feel like we need another trial. I said it, and I'm going to stand by it, because this is part of trying to get our justice system better. This kind of crap does not need to be happening if this truly happened. The next one said no. That juror declined to discuss the case or deliberations. No. And this one said no. She just said generally pay attention. Heard no body language comments. Okay, no and no. And then the next column, this one said yes, had chat, financial child support, saw clerk chat with others. See that again? No. You go in there, you say what you got to say to the whole group, and then get your ass out. You don't need to be, oh, are you okay? What's going on? Come see me. You can talk to me. Y'all, I can just imagine. The next one, spouse warned by Harpootlian of a subpoena if they did not talk. Okay. This person's concerns were denied statements regarding them in an affidavit of juror 785. Uncomfortable when Harpootlian waved the gun around. I would assume that would make me feel uncomfortable too. The last juror on this one, it was Creighton Waters in court argument who told jury to watch body language. So, in addition to the jurors, SLED interviewed court staff. And so, furthermore, even if Clerk Hill made any improper comments to the jury, the state has found no juror who will aver, whatever, that anything Clerk Hill said or did influence their verdict. Here's the thing: when you are working with a small group of people, or if you work in a small office, and somebody does something that is against policy and procedure, it is so difficult to report a small group of people and say, like, a boss or a coworker does something that they should not be doing, and you go report that to upper management or HR. Guess what? They're going to turn around and ask that person, and yes, they are going to tell them who said it, whether it's against policy or not. They're going to tell them, and I know for a fact this has happened. That makes things worse on the person that reported. Yeah, I could see how people didn't speak up, because who knows what would have happened. I'm not saying that was the right thing, but I'm just saying that I can understand why they did not bring it up during the trial. Okay. So therefore, the state respectfully requests that this court deny Murdaugh's motion for a new trial. And this is what cracks me up, because when you look right, I don't know if you can see it. I'm trying to get it up on the page where you can see it. Right here where it's stamped electronically, it says November 7th, 2023, 8:05 a.m., Colleton County, GS. Rebecca M. Hill. So that cracks me up that she she was the one that took that in, but that's who it goes to. But I mean, shouldn't they have gotten somebody else to scan that in, or whatever they do? I don't know. I just feel like that was a little conflict of interest. And I wonder if she's still I mean, I guess she's still working, but I would think anybody else, wouldn't they put them on some kind of administrative leave? All right, so this is her affidavit. And so I just highlighted the main parts. This affidavit is submitted at the request of the Attorney General of South Carolina to address specific allegations contained in affidavits attached as exhibits to Mr. Murdaugh's motion for a new trial filed October 27, 2023. And the reason it was the request of the Attorney General's office, and she is the Clerk of Court, so of course he's going to request her to do that. Because this is CYA, also known as cover your ass. There are numerous misrepresentations and false statements contained within the motion for a new trial, to which I was not requested to specifically address. So she's not going to talk about all the stuff. She's only going to do whatever they tell her to do. As such, this affidavit is not intended to address every allegation contained within the motion for new trial. I just want to know if she did that post at the Walterboro word of mouth. I really want to know that. As to the allegations contained within the affidavit of juror number 630, so basically it looks like they copy and pasted. A, I did not tell the jury not to be fooled by evidence presented by Mr. Murdaugh's attorneys. B, I did not instruct the jury to watch him closely. C, I did not instruct the jury to look at his actions. Again, copy and pasted. D, I did not instruct the jury to look at his movements. E, I did not say to the jury, this shouldn't take as long, blah, blah. So in other words, all she did was they took whatever those allegations were by those jurors and put it on here, and she said, I did not, in front of it. Okay, so here's what I like about these affidavits, because this is what I'm used to. The person would sit there and fill them out by hand. And of course, a lot of this is redacted because it has the juror's personal information on it. So on this one, the only time I had interaction with anyone was through the bailiff, other than one time when we as a jury was waiting to go into the courtroom and a comment was made to which his body language. Here we go again about the body language. I want to know who made the comment. And that right there that's enough for me for them to move forward, and let's just go ahead and question these jurors by whatever judge, because like I said, I mean, who do you get to do it? Because Judge Newman's a witness kind of too, and this is just a whole hot mess express, and I already got a headache talking about this because I am so tore up over it. Okay, I believe that my interaction with Ms. Hill, the court clerk, was limited to information from the judge or about important. Oh, okay. Long of a break we would get. I do not believe she acted outside her role as court clerk and acted in a very professional manner. Well, I'm glad that you thought that, but my question is, do you know what her role is of court clerk? Because I kind of do, because I researched it for my other video. Their manual is online and you can find it and download it or read it online, but it's on there and I read it. So I want to know, it didn't say anything about questioning jurors and telling them to pay attention to body language. And yeah, it doesn't say that. So moving on to the next juror, I pointed this out. To the best of my knowledge, that is one of those sentences I've noticed when I am watching trials, or even sometimes in everyday life. People say, well, to the best of my knowledge, a nice, more, I wouldn't say professional, but maybe way of saying, well, maybe I don't know. So that wasn't a good sentence for me. And I'm not hating on the jurors. I'm just saying that these affidavits that the state got from these jurors doesn't prove to me any different than the ones that the defense got. When you ask somebody to fill out an affidavit about whatever you need the affidavit for, it's very hard for them, and especially they don't know what to do, and it's kind of scary, and they feel dumb, and they're like, oh, I don't know what to write, blah, blah, blah. And so you kind of like give them like a prompt, a writing prompt. And, like, what happened? What did you see? Did you feel this way? I have not been contacted by the defense regarding the new allegations or other topic. Ms. Hill spoke to us as a group, which is how it should be. I just can't see them saying she spoke to us as a group, but like, what did y'all say to prompt that juror to say, well, she spoke to us as a group? All right, moving on to the next juror. Talking to Miss Becky about me not using the stairs because of my knee injury again, and I totally get this. I had bad knees. You got to talk to somebody, but that goes back to that thing where I recommended, like, hey, raise your hand, say out loud in front of the jurors, you need to talk to, Miss Becky, and then set up and talk to the judge and Miss Becky in his chambers privately, not go to the bathroom and gossip. But that is so burnt in my brain. I don't even know if that's true. Okay. No one, here we go again. No one from the defense team ever reached out to me pertaining to the Murdaugh trial. I was okay with these affidavits until I started seeing patterns, because I always look for patterns. And yeah, they told them to write that. And when I say told them, they questioned them so that when they go, look, they didn't talk to this juror, so why are they only talking to these jurors? Just don't be playing those kind of games. This interviewer agent, she had the person, they wrote what they wanted to say, and then there was the question, and then they answered. She had a question, and then they answered. So I'd rather have that than just have some kind of random, they didn't contact me, and then 2 or 3 juror things later, they didn't contact. And then in this one, again, we got the question, and then the juror would put like no. And she wrote for this juror, so maybe they had trouble writing. I have carpal tunnel, and so I have trouble writing sometimes. My mother has tremors, so sometimes she has trouble. So I'm totally good with that. I do wish there was somewhere in here that they would make that known that, this person was unable to write, so therefore interviewer, wrote the answer or, whatever the case. And then where it's all redacted is where the juror initialed that was their response. So I'm okay with that one. Did any court official question you or any juror prior to deliberation about decisions of the jurors regarding guilty or innocence of the defendant? No, not that I'm aware of. Y'all, that means 100% they do not know. Not that I'm aware of. When you hear somebody say, not that I'm aware of, they don't know. I wish they'd just say, I don't know. Here we go. No one pressured me into making my decision. And no one from the defense team called or came by my house. Okay. Now these are exhibits by court staff. They're just general, this person, I do not have any personal knowledge. In other words, they're saying, I have no idea. And then they're going to say what they're doing. I am glad she said that, because this is a worker and she is saying, I do not have any personal knowledge of that bullcrap that was going on over there. All I did was my job. And so I was good with that affidavit. Okay, the next one. Oh, I said this one's probably the most honest, but then I feel like they were all pretty honest. This one said, I did not observe Ms. Hill or any other court employee speaking with any jurors during the course of the trial except the bailiff that was assigned to them. I was asked to look through social media for a post regarding a juror speaking out. None was found. An apology post. Blah, blah, blah. So in other words, they just said, I didn't have nothing to do with it. All I had to do was look to see if there was any apology post on Facebook. And that was it. I am not in the middle of this poo pile. Okay. All right. And then we got the bailiff. And I really believed his statement. Personally, hear anyone, interface with and try to influence the jurors. So, I really liked his affidavit. It's strange how looking at somebody's writing and how they word things, I feel like you can really, it tells you something about that person. And no, I'm not saying I got some kind of superpower. I'm just saying it's just my experience with dealing with the public. Okay. So, this is a voluntary statement supplemental. So in other words, like when they run out of space on that first page of the affidavit, then they'll give them like a supplemental to finish writing. And they went ahead and did like a question. This person, I just felt like they just filled this out just to get it over with, like, okay, I'll write a few things. And then it says right here, the clerk of court performing. In other words, they didn't witness anything different than performing her duties. Okay, then what are her duties? I know it's not questioning the jurors, that's for sure. Time. Okay. Be safe. Be aware of your surroundings. And please do the right thing.